on the record.
We are on the record in the Lovelady matter, case D19-593-140D. Please confirm your appearances.
Good afternoon, Judge Audrey Beeson, Bar number 10511, on behalf of the plaintiff, Jessica Lovelady, who is present to my right.
Good afternoon.
Good afternoon, Judge.
And Your Honor, Louis Schneider, 9683, on behalf of Michael Lovelady. He's present here in my office. Judge, I'm not feeling real well today, so I didn't think you wanted me to come down to that courthouse. And I found out my client that I saw late last week believes that she has COVID. Now, I've had it and I've had the vaccinations, but I feel like I just have a low-grade flu, but I didn't think it would be a good idea to come in.
Okay. All right. And Ms. Hauser, go ahead and confirm your appearance.
Good afternoon, Your Honor. Michelle Hauser, bar number 7738, guardian ad litem.
Good afternoon. Any developments since we last had a hearing?
Judge, I did send draft number 6 to Mr. Schneider and Ms. Hauser today. I don't know if Mr. Schneider and his client have had the opportunity to review it. I was out of the office on Friday, so I sent it about 11 a.m. this morning.
Okay.
Your Honor, we have looked at it, Judge, and we do not want to mix and match these assets. We don't disagree with the assets that need to be divided. It's the manner in which they're being divided that I've got a problem with. Well, we agree with it.
Let me do this, because one thing I do, and the intent of today's proceedings was not to undo or redo what had been agreed to. So I want to be clear about that. In fact, the terms of the agreement were placed on the record with very specific detail by Ms. Beeson. And at the conclusion of those terms being placed on the record, I specifically inquired of both parties if they agreed to be bound by those terms immediately under local rule, and both parties affirmed their agreement. So that's one thing I wanted to do. I had a chance in the interim between the time we were last in court, and this is not something I had done prior to that hearing, but I had taken notes when the terms were placed on the record. I felt it was important to watch that hearing again. And I want to state, just for the record, and go through my notes after rewatching the hearing, because both parties affirmed these terms. So these are the terms. Now, there were areas that needed some clarification. There was going to be follow-up work, but that's not anything that should hold up the finalization of the final order, recognizing the parties are already divorced, the decree of divorce, bifurcated decree, having been entered on February 23rd. So this dates back to April 22nd. I just want to go through and place these records on the these terms on the record. Then we can have certainly a discussion about any of these follow-up items and areas of clarification, or if there was some type of a misunderstanding. When we resumed the proceedings in the afternoon and counsel reported that the matter had settled, there was some discussion about the apportionment of defendant's sick leave and vacation time, whether it was divisible. Mr. Schneider requested until the following Monday to research Nevada Supreme Court cases about whether sick leave has cash value. The agreement was that if sick leave and PTO is included, then defendant owes plaintiff $3,533.74 as in for equalization payments in exchange for the bank account division. If not, using the sick leave and PTO, the amount was $1,377.24. There were 2 whole life insurance policies identified Northwestern. $12,137.25 was the cash value that was reported confirmed to the defendant. The Gerber Whole Life is a policy for Abby. Defendant was to maintain that policy. There was no offset in terms of property division. With respect to 5104 Elk Falls Court, the mortgage as of November 30, 2020 was $218,159.79. It was to be appraised, and with the cost of the appraisal to be divided, there was discussion about using the company that did the prior 2 appraisals to conduct that appraisal. The timeshare was confirmed to the plaintiff as her sole and separate property. There was recognition that the defendant had paid, I believe the defendant had paid $12,000 to pay off the the amount owed on that asset. With respect to vehicles, it was reported that there was no equity. 2014 Dodge Ram to the plaintiff, 2011 Dodge Charger, 2012 Ford Escape, and another Dodge, all confirmed to the defendant. The retirement accounts or pensions, plaintiff's 401k at MGM as of December 3rd, 2020, had a value of $301,716.58. Although 4 years would be recognized as the plaintiff's separate property, she waived those 4 years based on the timeshare payoff made by the defendant. The defendant's 1/2 share is $150,858.29. City of Henderson 457B had a value of $68,221.87 as of December 3rd, 2020. The plaintiff's 1/2 of that retirement plan would be $34,110.94. Deducting her share of the City of Henderson pension resulted in an amount of $116,747.35 of the deducting that from the share of the MGM 401k. Giving credit for the life insurance that was confirmed to the defendant, the plaintiff's portion or interest in the life insurance, the resulting amount would be $110,678.73. Based on the updated equity in the residence, plaintiff will reach out to a CPA to determine how pre-tax dollars comport based on that, on those allocations, and the defendant would be given credit towards the buyout. With respect to pensions, the plaintiff's union pension, information will be forwarded and provided to Las Vegas, to Mr. Weinset, who will determine if there is cash value. If not, both retirements will be divided per Gamma Fondi time rule, with a qualified order being prepared by Las Vegas Quadro. With respect to personal property, apart from 2 Glocks that were identified as separate property, each would keep whatever they had in their possession. With respect to the, there was discussion about specific debts that were identified as part of the discussion. Let me look at my notes from that. There was a City Simplicity, City Thank You and Discover in plaintiff's name totaling $49,462.19. Defendant had a MasterCard and a Discover totaling $20,679.08. Then plaintiff reported promissory notes totaling $38,740, and defendant reported a promissory note of $5,000. The plaintiff asked for an equal division. Defendant asked for the promissory notes to be excluded. $15,726 was the amount that the defendant took out in loans against vehicles. I had previously ordered that the plaintiff could access her retirement account, authorized to use retirement, but she did not do so. Instead, borrowed money, which is part of the promissory notes that were previously discussed. We then discussed total fees paid. Defendant had paid $27,893.69, $7,500 of that to Mr. Schneider. Plaintiff had paid $15,000 plus $24,406.50. Owed $4,840, independent of whatever was being incurred that day in court, and those fees had been paid from the plaintiff's parents. I indicated at that time that I look at the debts at the time of separation. which oftentimes gives me a defining picture of when the marriage was irretrievably broken. We had some discussion about the promissory notes and how I look at various debts, including credit card debt. And noted that had the plaintiff pursued the loan against the retirement accounts, the 401k would have been worth $15,726 less. And we had some discussion about needing to determine the tax equivalent value of that amount based on the fact that it was going to be taken against, the plan was that it was going to be taken against retirement accounts. Ultimately, I shifted gears when it came to that offset, and rather than deducting from retirement accounts so that we compared apples with apples, that amount, the $15,726, should be offset or included as part of the equalization payment from their marital residence. So it is comparing similar dollars, with each party being responsible for their respective promissory notes, which again on the record appeared to be accepted by both parties. With respect to credit cards, there was going to be some follow-up needed on both sides, but we did spend some time talking about that line of demarcation. Date of separation was reported to have been February 7th, 2019, and counsel for the parties were going to look at the amounts owed on those credit card balances at that time. With the court also clarifying at the end of that discussion that to the extent the balances had actually gone down, then obviously that would be taken into account, but the plaintiff reported that they'd gone up rather significantly, so that didn't appear to be the issue. Defendant was to make best efforts to refinance the residence within 3 months after the appraisal was completed. Mr. Schneider was going to reach out to Mr. Ponzo to obtain some type of an invoice regarding his fees. Moving forward, the GAL fees would be split, Dr. Hart's fees would be split, and upon getting that disclosure from Mr. Ponzo, those fees would be split. Child support was set at $188 per month, no arrears, each to provide insurance with unreimbursed divided equally pursuant to the 30-30 rule. With respect to the order to show cause, I emphasized I was more inclined to be looking forward prospectively, there had been concerns, and this came up during the trial after listening to a recording that had been offered, concerns about both parties, which ultimately I think perhaps may have been part of the settlement that was ultimately reached, but I was not inclined to look backwards and essentially hold out on the order to show cause or set further proceedings on the order to show cause. We set a status check for June 28th, 60 days to draft the proposed order. Both parties were canvassed at about 49 minutes into that hearing. Both parties waived the necessity of the court making findings of fact and conclusions of law and agreed to be bound by the terms at 54:30 of that hearing. So that's a summary of the terms that were placed on the record. So I do recognize that there were follow-up items, but certainly the order, which both parties agreed to be bound by, would necessarily conform with those terms that were placed on the record.
Judge, I have complete agreement with everything you're saying. I really do, except for two small things. One, the $15,726, my client borrowed that money, has promissory notes he's making payments on. That's a windfall to her if you give her the same $15,000. I have the promissory notes. I sent them to the court. I sent them over to Audrey, and she won't listen to me, Judge. It's not that he got $15,000. He's paying that money back. He had bank loans and used those cars as assets.
Okay, but
at that time.
But hang on. Here's where this is where that issue comes to a head. So, and I noted as I went through those terms that when you divided the vehicles, plaintiff received the Dodge Ram, defendant received the Charger, the Ford Escape, and another Dodge. So therein lies the issue. When I put those terms on the record, the report to the court was basically that there was no equity in the vehicles. That basically It's an even exchange. So that becomes the issue, is the $15,000 that was taken out, it would be no different than if you took a loan out against a 401k, which I authorized the plaintiff to do. Ultimately, she would pay that back to herself after the divorce, but that $15,000 was removed from the division. So she's not, the community suffered by the $15,000 being taken. Now, the vehicles, if they were valued and it was an equal division on both sides, that took into account the fact that they were then encumbered by $15,000, then it's not, that argument doesn't fly, because the value was stripped away as part of the division of assets. It was stripped away by them, those assets being encumbered by the $15,700 and some odd dollars.
But my client owes that debt entirely. He's paying that debt back, and Audrey's trying to take a $15,000 credit on the money he's paying back.
No, that doesn't make sense, Mr. Schneider. Again, say he didn't take out the loan. Say the loan was not taken out at all. Then he comes into the settlement with about $15,000 to $16,000 in value for those vehicles. I'm sorry, Judge. I think that the court is assuming that the cars are worth that. The cars are not worth that, Judge. They don't have that kind of value. They just had to have some asset to put on the notes that he got from the bank. They couldn't be unsecured. They had to be secured by something. But the court believes that there's representative of the value of those vehicles. That's not even close. My client's eating that debt. He borrowed that money. I don't think they get a $15,000 credit on the other side of the ledger. That's my only point.
Judge, Mr. Schneider made this argument, and you addressed it over about a 14-minute period from 150 to 204. He made this exact same argument, Judge.
And Your Honor, just to be clear, because I wasn't going to participate today, but then I got all the pretrial memorandums. In advance of this hearing, trying to get this resolved for the best interest of Abby, because all this fighting's not helping the parties move forward in their lives and focusing on Abby, where the primary focus, in my opinion, should be. At no charge to the parties, I ordered this case, the prove-up hearing, which if you're not familiar with Otter, it does a transcription of all hearings. It's kind of a cool tool. And I sent it to all the parties so they could see what the terms were in hopes that we'd avoid today. And exactly what Ms. Beeson said is true. I mean, that's on the transcript that was provided to both counsel. I mean, it's not like a clerk-certified transcript. It's funny at times, but it's like 98, 97% accurate.
Well, and again, that's why it was incumbent upon me to go back and take a look at what was placed on the record, because that defined exactly what the parties agreed to and accepted at that time.
If that's what the court's going to order, Your Honor, that's what the court's going to order. But the other problem I have is I called Mr. Nick Ponzo and I asked him for his invoice, and he refused to give it to me. He refused to discuss the case with me at all. And to this day, no one has produced an invoice from Nick Ponzo. And Ponzo, they've contended that Ponzo was their expert witness, that he wasn't ordered by the court. And if you recall, it was ex parte communication with Ponzo that we have no intention of paying for, that got him out of this case and got a new therapist involved, Judge. So we have never seen an invoice from Ponzo, and he simply refused to give it to me. I'll never use that guy again.
Do we have, and that was something that Mr. Schneider was tasked, any luck in getting invoices?
Mr. Ponzo reached out to my client and asked if that was agreed to. My client said yes, forward them to him. I did give Mr. Schneider all of the receipts. Again, Mr. Schneider.
No, she gave me a bank statement.
That was resolved. This is what has happened every single hearing. Just like last hearing, he said, well, custody is not resolved and child support is not resolved. This is the continued issue. These issues are resolved.
Oh, she did not give me his statement, Your Honor. She gave me her client's bank statement saying this is what I paid. I want to see an invoice from Ponzo, or we're not going to pay for Ponzo. He's not ever shown me an invoice, ever, and he refused to give it to me. I don't know what he's hiding or what's going on, but we've never seen an invoice.
Well, listen, and that was part of the terms.
Yes.
And so certainly I expect before any payments made that Mr. Ponzo, and that should be part of the order, is that
And it
that
is.
Mr. Ponzo is to, that Mr. Snyder's entitled to receive an invoice. Not just the receipts. I know receipts were discussed at that hearing, but an actual invoice. But
But my client also can't control Mr. Ponzo. We again made sure it was clear that he could release them to Mr. Schneider. It is in the order that Mr. Schneider refuses to sign. I do not know what else we can do.
okay. But effectively, that is what would trigger payment.
Well, and there's an offset. So because I only, as of August 24th, got the amount that Mr. Lovelady has paid the GAL, it's an offset.
Okay.
My client actually owes him $498, which I took out of the community property equalization from the cash assets to reduce
Okay.
what she is owed. So we're not asking
Just because there might be an
to pay it.
They jumped up and down and said that he was their expert witness, and now they want us to pay for something without a bill, without an invoice accounting for his time. There's something weird. I've never had a therapist refuse to give me an invoice.
Well, again, to be very
Your
clear,
Honor,
the expectation of the court was that there would be an invoice.
And Your Honor, I just emailed Mr. Ponzo because I have a lot of cases with him where I'm the JAL and asked him to forward them to me, and I'll distribute them because this
Okay.
is just a wasting time.
Yeah, we just need
And I've
those
not
to be
had a
distributed.
problem with Mr. Ponzo
Yeah.
in all these years.
And that's my expectation. So that's by way of clarification, if that is considered clarification, that's where I'm at as it relates to those two issues. Are there other issues?
Your Honor, the only issue I have is that we don't want to use pre-tax dollars and mix and match. My client's going to sell the house. She can have her money. We're going to take her 401k. We're going to use quadros, but we're not going to mix and match. I spoke to an accountant, and it's so much guesswork to try to figure out what the tax liability is for somebody using pre-tax dollars and after-tax dollars. We don't want to mix them. We're just going to divide everything up 50-50 and be done.
Which is what my proposed order does.
Okay, and I think that makes sense. And that kind of was the direction we were going. I think there was only one area that I recall that we kind of we looked at perhaps the plaintiff consulting with the CPA, but I agree. I think it's cleaner if we just keep, and that's one reason when we got into the whole that offset amount on the loan for the vehicles, it just didn't make sense to take it out and try and figure out what the tax consequences were, even though I had authorized the plaintiff to take that amount from her retirement. So I don't have a problem with that. So sounds like we are there.
Yes, Judge, and again, this was his client's request because he didn't think he could refinance. So we were trying to work with them. When it became apparent that we couldn't get a figure, I made 2 drafts. I caught some errors when I came back today, which is why I sent a clean draft today, and it just does that. It divides everything.
Okay. All right. So you have that clean draft, Mr. Schneider?
Have the draft, Your Honor. I have not gone over it item by item, but if it does exactly what we just described, we'll have no problem signing it.
Okay. So that's my expectation. So has the house been listed then?
My client's in the process of moving right now, Judge, but the problem is that how do I sign this decree without having Nick Ponzo's invoice?
Judge, this has been going on for 4 months.
I don't care if it goes on for 4 more years. I'm not going to let my client get run over.
And that is not what is happening here. And my client has paid thousands and thousands of dollars to try and get this order resolved. And this is the first time we've actually gotten detailed information. As you can see by my pretrial memorandum, all I would get is vague information, vague accusations, just like the defendant's pretrial memorandum today.
Okay. Well, but again, my expectation is, and Ms. Hauser's going to follow up with Mr. Ponzo to get the invoices. Both parties are absolutely entitled to those invoices, and that should be part of what is discovered in exchange. So that becomes the issue of what if, and I don't see any reason why Mr. Ponzo would not release those invoices. Ms. Hauser, when did you submit that request?
Just now.
Okay.
Because I didn't know this was an issue until this hearing. I've been on every email on the financials because it's not good for Abby trying to get this resolved, because this is just not good for Abby. But yeah, I just emailed him. I'll get him from Mr. Ponzo. I have no problem communicating with him.
Well,
Judge, I have his refusal to give me the invoice in the email if the court wants to see it.
well, I don't necessarily need
You
to
can
see
forward that to me. I want to see that.
Just,
All right.
I don't necessarily need that, Mr. Schneider. The bottom line is I agree that the invoices should be produced. That's part of the agreement. That's part of my order. Now, Mr. Ponzo is not a party to this case, but my expectation clearly is that those are going to be exchanged. Now, that being said, I don't necessarily view that as a contingency that should hold up the entry of this order. I understand it could result in other proceedings. If he never produces invoices, I think that's a problem, and that's a legitimate issue that the defendant has if there are no invoices that are produced. I'm not expecting that to be the case. I expect something to be produced, but it wasn't as though these stipulated terms that were placed on the record were contingent and the order would not be submitted or signed off by the court with that not occurring. I think there are other remedies that I may need to entertain if that happens, but I'm not expecting that. And I appreciate the guardian ad litem's willingness to step in, and if Ms. Hauser has a connection with Mr. Ponzo, can get those orders or those invoices, then more speed to the process. Let's get it done.
That's fine, Judge. So you want the order in, and then we'll wait and see what happens with,
Yeah.
if Ponzo doesn't, or we don't agree with his invoice, we'll wait and deal with it later?
Deal with it later. It shouldn't hold up the entry of the order. Let's get that. Let's get this closed. And there are already issues that I know are percolating and have arisen with respect to Abby. And I agree. This is just not healthy for her to have this hanging over everyone's head. So it was helpful for me just to rewatch the hearing on the 22nd.
And Your Honor, with regards to Abby, I did ask Ms. Beeson to specifically write in EDCR 5.301, which she did type in to remind the parties not to discuss this litigation with Abby. I am concerned about future discussions because I know, speaking with the parties, that everybody thought it would be best for Mr. Snyder's client to maintain the house for Abby. Abby's connected to the house. And now if we're going to sell the house, I don't want it to turn out to Mom made me sell the house or any communication. I mean, this is a choice of selling this house that these two parties jointly have made, not one party versus the other. So there should not be a discussion regarding why the house is being sold, etc., to Abby, because I am concerned, given how the relationship with Mom is going, that this could be a further setback.
Well, Michelle, you should be aware that Mom made representations to Abby that they could stay in the house until she was 18, and that clearly can't be done. So Mom set herself up for this. We didn't talk about this whatsoever, but Abby was complaining to my client that Mom said we could stay here until I was 18.
Well, Mr. Snyder, you're assuming Abby's being truthful, and you're assuming that there's not triangulation issues. So things have changed, and we're adults, and Abby should be told that this is what both parents decided to do.
Well, I didn't speak to Abby. This is coming through my client, so you know.
Well, Abby has said a lot of things that have not actually been accurate. So we'll move on.
I think the bottom line is, I think if Abby, certainly what would be damaging is if Abby is told, your mom is making us move out of the house.
Mm-hmm.
That would be very...
That's not happening.
And
That's
so
not
that,
happening,
that can happen. And that's, to Ms. Hauser's point, I think it has to be portrayed as a joint decision, because in many respects, that's exactly what it is. Even if that's the feeling, well, I can't pay out that equity without selling it, that ultimately has to be the end game if refinance is not an option. Certainly that was something that you both contemplated, and defendant had the option to refinance if he wanted to do so, not compelled to, but that certainly was an option that was something that he could pursue if he so desired. But if not, if it's not feasible, not practical, then we list it. Now's a good time to sell it and maximize equity.
And Judge, I'd like to know how Mr. Lovelady was able to list it, because my client's on the home, she would need to sign off.
Well, it has been listed, correct?
No, I don't believe it has. Has it been listed? No, but it's going to be listed forthwith, Your Honor.
So the plaintiff will need to cooperate in signing off on that listing. And then that is going to essentially be the assets that's going to be used to make these payments. And
Your Honor, to avoid future disagreement, should we just decide to pick a realtor now?
I think it makes sense given the history of this case. Certainly, I can lay out a protocol. Typically, I will have the party who's living outside the residence select 3 agents and submit those 3 names to the party who's living in the home.
That's fine, Judge.
Okay. So how soon can you get the defendant 3 names?
Tomorrow.
Okay. All right. So by the close of business tomorrow, plaintiff will provide defendant with 3 names, and then by the close of business on Friday, the plaintiff is to select one of those 3 agents. Parties are to cooperate with respect to anything that needs to be signed to effectuate the sale, and the house needs to be maintained in a showable condition so that people can inspect the house and hopefully maximize the sale proceeds. Okay, anything else?
That covers it, Judge. Thank you.
Well, Judge, I'd like to leave my copy that's already signed, and then Mr. Schneider can sign his copy and submit it.
Okay. All right, so
Your Honor, as long as it's an agreement, as long as I'm in agreement with the terms, absolutely. But
So here we go.
I've not. You know what, Audrey? Don't interrupt me.
okay, no interruptions.
Your Honor, as long as it's not mixing and matching and voodoo economics, I'll be happy to sign it as long as it's exactly as the court just reported.
Well, here's what I direct. I'm going to, Ms. Beeson's going to leave what she's prepared with the court. Mr. Schneider, is that something you can get to me? What I'd be looking for from you is either your signature on the same order, or if there is any provision in that order that you believe is not consistent with what we've discussed today or was placed on the record back on April 22nd, that you note that on what you sign and submit that to the court. Copy Ms. Beeson with what you submit to the court, and then ultimately I'm going to end up signing off on what's submitted to the court.
Sure, Judge. My client's here. We can probably get it done in the next hour.
Okay, so I'll say by the close of business tomorrow, you're to have that to the court. I'll take Ms. Beeson's right now. And then my intent is to have this signed off either tomorrow or the next day.
Thank you.
Okay?
Good.
All right.
Thank you so much, Judge.
All right, thank you for your appearances.
Thank you.
Thank you.